Can you hear me?
NRS 4. Oh, I can hear you.
I fixed it.
This is case FE 23- in the matter as to versus. This is a time and place set for a continued case management conference. Can have the record reflect that this matter is being held remotely in the court, and all participants are appearing simultaneously through audiovisual transmission, either by video conference or by telephone. That I'm physically located in Reno, Washoe County, Nevada, which is the site of today's court session. The official record is the JABS recording. Gonna go ahead and begin with appearances for the record, please. So, Mr. Would you please state your name for the record? And I'll have the record reflect that Miss is here, however, and she can hear me. However, I cannot hear her, and I'll just have her signify an agreement by nodding her head at this time. All right. Miss is having audio difficulties, and actually I'm gonna have Mr. sworn at this time, since he's the only one that can be sworn, to confirm his agreement to continue the hearing for an in-person hearing. So, Mr. able to stand and raise your right hand to be sworn by my clerk, please?
Yes, Your Honor.
You affirm the testimony you're about to present should be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. Please be seated, or you can put your hand down. I think
Yes.
you said you were walking.
Yes.
So, Mr. You don't have an objection to continuing this CMC for an in-person
No.
hearing due to technical difficulties?
Not at all.
Okay, and then Ms. agree that it would probably be easier for you to come to the courthouse for a hearing? Okay, and well, the problem is, well, where are you? Are you in Reno? Okay.
Yeah.
Well, the problem is, if you don't have audio, you have to come into the courthouse, even if you don't want to. Okay. So, unfortunately, you're going to have to come into the courthouse. Let me get a new court date. I'm going to look on my calendar. I'm just going to try to find the next hour available. Let's see. And we'll just have the record reflect and confirm that our Nevada judges is recording the proceedings, as there was no objection filed by either party in the time allotted. Let's see. Sorry, I'm just looking for a new court date where I have an hour available. So we could do May 14th. It's a Wednesday at 4 o'clock.
For me.
So May 14th, 2025 at 4 o'clock is my next hour available. Sorry, we're just pretty busy here, unfortunately. Would that work for both of you? I do have time on May 19th, that Monday as well. But is May 14th okay at 4 o'clock?
For me, it is.
Okay, Miss May 14th at 4 o'clock. Okay, I'm acknowledging your nodding in agreement. Miss, get to file your answer or family court information sheet. And actually, I would like updated financial declarations from both of you. This matter was held in abeyance due to Child Protective Services intervention. And I'll go ahead and indicate just my acknowledgement that matter has closed, as well as
Can you hear me?
NRS 4. Oh, I can hear you.
I fixed it.
Oh, great. Okay. All right, then let's, I only have about 40 minutes before my next hearing, but let's try to proceed. Okay.
Okay.
Okay. All right. Okay. Good job, Miss. All right. So, I was indicating that pursuant to NRS 432B.292E, the court finds it necessary for the public disclosure of confidential information regarding Washoe County Human Services Agency, which is necessary to determine an issue before the court in regards to custody. That I believe this matter was reset.
Alex here. I usually cut in when there's some kind of, I guess you could say, problem with camera access or public access to family court. In this case, I'm actually blown away that this judge has cited NRS 432B.290 sub 2 sub E, because this law is one of the laws that we have been aware of for a very long time that has been very frustrating for us, because there has been sort of this idea that the Falcone decision and the other cases that have followed created a right to access to family court, but that there were certain federal statutes that prevented our access to certain types of cases, namely abuse and neglect cases, also known as CPS cases, also known as 432B cases. And this has been especially frustrating because the First Amendment does not come from the state constitution. It comes from a federal constitution, our federal constitution, the federal constitution of the United States of America. And it is just as capable of nullifying a state statute that interferes with public access as it is a federal statute. So this idea that there were federal laws that were still going to block access to certain types of family court cases was annoying in the sense that I just described, in the constitutional sense, but also because of the statute that District Court Judge Cynthia Lu just cited. And I believe she is the first family court judge to have cited this statute. And in this case, the issue of sealing and closing CPS cases isn't really going to even get to the point of the First Amendment, because there is a carve-out in the statutory scheme that allows for the court to make public disclosure of certain information that would be otherwise sealed and confidential if the court determines that a determination of an issue before it is necessary. And that's exactly what we've been saying for such a long time. If it wasn't for this statute, then we would just proceed with a strike down under the First Amendment, and any sort of argument that, well, the Falcone decision doesn't apply to federal cases would, go right out the window, because the First Amendment's a federal amendment from the federal Constitution. It would just nullify any federal authority that interferes with our public access. Well, there may be some other extraordinary reasons as to why, but if there is some other reason as to why public access wouldn't be available, it wouldn't have anything to do with the concept of a federal law. It would have to be some other reason completely unrelated to the fact that it's a federal law. And so when it comes to this issue of, well, the state might lose federal funding if our Nevada judges and other media outlets are able to cover these cases where CPS records are, brought up, it's quite silly, because we don't even really get to the constitutional issue that was mentioned in Falcone, because the law provides for exceptions when a judge has to determine an issue. And that's totally a reasonable position for Congress to have taken, and it does not render the law pointless, because we've heard stuff like that before. The records are overwhelmingly confidential, and the cases that actually get to a courtroom are, I wouldn't even say a single percentage point of the records that get raised in those cases. So this is one of the rare times when I will sort of step in and give a big kudos to District Court Judge Cynthia Lu for being aware of this statute. And I do hope that more family court judges, take a look at that statute, because it does provide that, yes, CPS records are confidential in the general sense, but once you're sitting on the bench making a decision in open court, and some of that information is necessary to make that decision, there is a carve-out in the law. And one more thing that I do want to mention is that this statute is not just something that Nevada came up with on its own. I do remember the congressional act, the federal act, contained its own counterpart to this language. If I remember correctly, it's not identical, but very similar language. So it would seem that even Congress was aware that while this information needs to be confidential, there may be certain circumstances where it needs to be brought up in open court, not just family court, but if you think about it, criminal court cases. There's plenty of criminal court cases involving criminal child abuse, and CPS is involved, and those records might pop up in those criminal cases, and there is no sort of knee-jerk reaction to close an entire criminal case just because of one of those records.
After the Child Protective Services case closed. And actually, I'm gonna have Ms. sworn at this time. So Ms. Can you raise your right hand to be sworn by my clerk, please?
Do you affirm the testimony you're about to present should be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. So I'm just gonna confirm that the matter was closed, Mr. Is that correct?
That's correct.
Okay, and you reunified with the child, is that correct?
That's correct.
Okay, can you indicate what has been missed contact since that case closed with the child?
Up when it closed, up until about 30 days, about 30 days ago-ish, there was not a lot of contact at all. And then 30 days ago, approximately, our condo flooded for me and my daughter. So I missed her a little more as of late.
Okay, so what's been the schedule?
There's been no schedule. Miss kind of helped me out with kind of being able to sustain right now. So there's been no schedule, really.
Okay, so is the child staying with Miss?
No, child staying with both of us, but the child has been staying with me, which I'm not happy about. But
Okay, but it's due to necessity, right?
yes.
So you've been exercising joint legal and joint physical custody, correct?
The joint physical, joint legal, not. I wouldn't say joint physical either, because she's just helping me out every couple of hours, like a couple of hours a day, like that. It's better than what she had before, which was nothing.
So she only has the child a few hours a day?
Right.
So Miss, does the child stay overnight with you?
Okay, so no, the child does not stay overnight. I guess, like he said, I guess I'm getting her because it's better than nothing, which I was getting. No, she doesn't stay overnight with me. Only
Okay,
right now because I'm helping him out.
Okay, well, all right. So you have unsupervised contact with the child, correct?
Mm-hmm.
Okay. When your case ended with Child Protective Services, were you having supervised visits or unsupervised?
Mine were unsupervised. She was not. She was supposed to be still supervised.
Mr. is asking.
What was that?
So my question to you, Miss, was when CPS case was ending, were you having unsupervised or supervised visits?
Nothing.
No, that's not my question.
Nothing. I didn't have anything. No contact with her. Like, this is stupid.
Okay.
She gets taken away from CPS, still no contact. Get back into the system with her father. I still have no contact. It has not yet been different. I go to jail, still lose time for my daughter. This is stupid.
Okay. So my question was, did CPS
I don't know what CPS did. I don't know. CPS, I don't know.
All right. Okay.
I have no idea.
All right, Mr. According to what you were saying, had supervised visits, right?
Right. Well, actually, what Ms. is for, she can correct me if I'm wrong, but Ms. participating with CPS at a certain point. So, at the end of when I got the child back, she had been not participating or contacting with CPS, or had no. She told them to, don't contact me no more. So she didn't have any visits or anything like that. But they would have.
But right now, she's having the child several hours a day, right?
Yes, she is.
And it's unsupervised, correct?
Yes, it is.
Okay, Mr. Speaking really softly, so I'm having a little problem.
Yes, it is. That's all correct.
Okay, So is it during the day? Is it in the evening?
In the
What?
evening. It's in the evening.
Okay. And you said it was random, so I don't know what you mean by random.
Well, it depends on what's going on because I'm trying to find a new place right now because we can't go to our old place because it's under construction. So the last month has just been a total mess for us. So everything is we're just winging everything day by day. So
Okay.
that's what's going on.
So, is there a reason why you don't think should have overnight visitation?
Yeah, there is.
Is there a
There-
reason why you
Um,
think I'm her freaking daughter back? Because I'm over
Miss,
this whole case.
Miss, I will hear from you in a moment. Please don't interrupt.
Well,
So,
he's getting a lot of
Mr.
talking to. I'm just gonna leave the
Okay,
case. I'm over it.
well,
Shit. You keep talking about it. I just want my 50 back so I can leave this man alone. Nothing's getting settled. We just keep going more and more and more. I'm getting less days with my daughter, less days with my daughter. No
all right,
days with
well,
my daughter, no overnight with my daughter.
okay, well, here's a concern for the court, just to let you know. All right, well, Miss, as I'll have the record reflect, voluntarily left the proceeding. So Mr. At this point, I can issue my temporary order even though she's absent, but I would like to set a settlement conference / trial. And if chooses not to participate, then I'll have you hear your testimony for a final order at that point, okay?
Yep.
Okay,
what's
so
the-
just to explain the
go-
process. So right now, how many hours a week does she visit the child?
I mean it's about 3 to 4 hours a day. But I have to
Okay,
do it because I have to do it. There's concerns. Like I have concerns.
okay. Well, you still didn't state your concerns, so do you want to state them or
Yeah.
not?
It's not her home. There's no place. She has no no space of her own. It's on a couch, so my daughter has nothing. To usually let her sleep there, what you can do sleep on the floor. There's that, and I don't know who she lives with. Um, I, it's my understanding that they're in a same-sex relationship. Um, it's just it's a lot of things that I don't condone going on. So
Well, my main
okay with it.
concern is, a child sleeping on a couch is potentially a poverty issue, which I normally would not hold against a parent. So my issue is whether or not it's safe and clean.
That's the thing.
So,
You don't know because she
and
wouldn't
you
even allow
don't,
CPS to come in and make a decision. So CPS wouldn't. She was living there when CPS was involved, and she wouldn't allow CPS into the house. Which CPS wrote a report on that they didn't know
okay.
the conditions of the child would be in because allow them access.
All right. So at this point, I do take into account that she did not maintain services with Child Protective Services. However, it appears you're in agreement with joint legal custody and primary physical custody to you, correct?
Yeah, yeah. I'm okay with that.
Okay. So then I'm just trying to have a temporary visitation schedule for her until I see you for your settlement conference trial.
We do have
And if she,
there's a protection order right now for me against her, and the protection order just says at my discretion her visitation is. So that's kind of what we've just been doing. I do believe the protection order is still in place.
well, I'm just reviewing the protection orders we have. And your last one was in 2023, correct?
No, I got one just like
Oh,
4
wait.
months.
Oh, 2025, it expired March 3rd.
Okay,
Mr.
so
It was
okay.
not extended, correct?
No, I guess not.
Okay, it's expired.
Right. Well, we had been
So
following.
So Mr. Situation, if you've been allowing her visitation
Yeah.
unsupervised for several hours a day. I'm not inclined to say she gets less because you've been
Here's the thing,
allowing
Your
it
Honor.
and the child.
Here's here's the thing, Your Honor. I've had to call the police twice because she took off with the kid. I let her see the child in my house. When I went outside, she took off with the child, and I had to call the police to come and get the child twice from her. I'm not going to keep going through that. So I've let the child at the house with her for two reasons. One is I'm not that far down the road, so I know it. So I feel like I got a grip on what's going on because she doesn't, the girl was letting her use the car, but since she doesn't have a license, she's not using the car no more. So she can't move around as freely as she was able to. But I'm not going to keep giving her my child, and then my child's coming back saying cuss words. My child's coming back, she's a different human being when she comes back from with her every day.
Well, Mr. You just told me that out of necessity, she is seeing the child
Right.
several hours a day.
And if I didn't
Correct?
need it, she wouldn't be.
If you didn't what?
If I didn't need her to, she wouldn't be. So when I go get my new place, she's not going to be.
Well, I think ultimately it'll depend on if she appears again in court or not. Because if she appears again in court and decides to proceed with this custody matter, I'm the one that decides. Do you understand?
I understand that, but have you read the CPS cases? Because I don't know what else, what other information you would need to decide.
What I did not read the CPS case because all I'm taking judicial notice of is that you reunified with the child and she didn't.
Right.
So that is why at this point, I'm not going to, even though there's a preference for joint physical custody, not award joint physical custody at this time, which is why I would agree with temporarily giving you primary physical custody. And all I'm trying to do is figure out her visitation schedule, which at this point,
you can't give her nothing because if you tell her you got 2 hours a day, she's going to take those 2 hours and turn it into 6 and do all kinds of stuff that you're gonna hurt me and my child. Like that's what you don't understand that she does. It's a hassle dealing with her. So you can't give her anything. You can't.
well,
I'm not understanding. I don't know if you understand what I'm saying, but you cannot give her something because of the way that she does things. Like she's just weird. I don't know, but you can't. But if you give her 2 hours, I ain't with all that, man.
well, Mr. The allegations you stated to me so far does not indicate that the child is unsafe for visitation, to be unsupervised for a few hours a day.
No, but because nobody does anything when she takes the child and 10 police show up and none of them do anything to her, she keeps doing it. So she's going to get the child from me during a visitation and she's going to not come back because nobody does anything. Nobody cares.
Well, you haven't had an order, first of all, Mr. Don't have an order. It's joint physical and joint legal.
Your Honor,
and
Your Honor,
law
we have it, Your Honor, excuse me. We have it. When you're done with CPS, it reverts back to the old order that was last issued. We do have an order.
There was no final order, Mr. And this matter was held in abeyance, and my order specifically stated there is no order at this time because it was a temporary order. So, Mr. really would appreciate is the ability to finish my comments without you interrupting me. All right? So at this point, if there's a court order, the law enforcement would enforce it, but you've given me no specifics of when or how she has withheld the child. So do you want to tell me?
Yeah, there's police reports about it. Like excuse me, I'm sorry that I don't have time to do all this stuff because I have such a mess in my life that I just, everything crashed down as the last one. That's why I missed the court date. But I don't have time to file all this stuff and do all this stuff because things are rough right now. Like we're just scrambling every day.
I understand.
My condo flooded.
Well, I understand that, but right now, because things are rough, you're having her take care of the child daily so you can get things done, correct?
Right. Right, yeah.
Okay,
So, I mean, you can't say, hello? You can't say
yes.
to her, all right, 4 nights a week, you get her between 4 and 9 o'clock at night, because sometimes those nights are going to exist for her. And then when they don't exist for her because of what things that I've got going on, then she's going to be calling the police over there saying I'm the bad guy.
So at this point, I'm gonna issue a temporary order. Since she's seeing the child daily, I'm gonna continue that time frame. This is temporary, Mr. You come back to court for settlement conference and trial, which is only for the next few months. Do you understand?
Yeah.
Then at trial, you can make your requests, and if she doesn't participate, then there may be a final order that will have a different type of contact for her. Do you understand?
Yeah.
Okay, so I need to give her the opportunity to appear for a trial, and if she chooses not to take that opportunity, then we can proceed with default and your requests. Okay?
Yeah.
Okay. So I'm going to allow her to have visitation 3 hours daily at this time, since it's been
Hold on.
flexible based on.
She's texting me right now saying she's bringing the child to the police station. So there you go. Because she's bringing the child to the police station right now for me to go.
Mr. If she doesn't want to exercise her visits, that's fine. Do you understand?
Yeah, but okay.
So,
But you're
okay.
going to give them to her.
So
She's going to bring the child to the police station because she doesn't know she has them. And so she's getting rid of the child. Then she's going to see she has them and then start to try to exercise them.
All right, Mr. The sooner we can finish up, maybe you can pick up the child, okay? All right. So I'm going to have child support continued as ordered in your child support case of FE 22, which the court takes judicial notice of. That you have Medicaid for the child still, correct?
Yeah.
I'm gonna have you continue to maintain the Medicaid, and any uncovered expenses shall be paid equally by the parties. I will once again order Ms. complete the children in between co-parenting class and filed a certificate of completion. Since she is not present, I'm not going to send you to mediation at this time. I am going to set an in-person settlement conference and trial. And that if she fails to appear at that time, then Mr. You can proceed with your requests, and we can take testimony regarding a potential final order. I am going to have her file her answer, family court information sheet, and financial declaration with her 3 most recent paychecks. And I'd like you to file a new financial declaration as well. All right.
Mm-hmm.
Okay. So within 20 days of this order. So let me set a hearing in trial. And she'll have notice through, I believe she has eFlex. Yes. So both of you will get this order through eFlex, all right?
Yeah.
All right, so let me get, I want to set at least 2 hours. Okay, we can set it. So I actually can set it on May 19th for 2 hours from 3 to 5. Are you available?
Yeah.
Okay. I'm going to also issue a trial order, which will be a separate order. And so for the trial, it will give you instructions regarding exhibits, witnesses, notifications. All right, and this is going to be in person at the courthouse, okay?
Yep.
All right. So at this point, do you have any other questions? Okay, so all these dates will be in the order, and
Well, yeah,
including,
there is some actually. I might have to leave this. I might have to go to my mom's house and live because we're displaced from a flood. I don't have the resources around here to continue up like this, so I may have to leave, and I'm taking the child with me. So
all right, well, Mr. If you're also wanting a relocation issue with the child, it just is another, you need to give Miss of that,
he's already
which
aware.
requires filing a motion to relocate.
Mhm.
So you'll have to, we do have those motion forms in our,
I got it. I know there.
okay,
I got it.
all right, so you'll have to do that so that she has the opportunity to address that. The issue is because you're such a short set,
Yeah,
it doesn't give her much time unless you file that motion right away for her to be noticed. Do you understand what I'm saying?
I do. I do.
So because she gets 14 days to respond to any motion.
Yes.
So that will be the only potential hiccup is if that's what you plan to do, then we
Okay.
need to, you know, address that time frame. But at this point, I'm still gonna set you for May 19th at 3 o'clock, all right?
Yes, ma'am.
And I am gonna put in this order your latest disclosure that you may be needing to relocate and your instructions as to how to proceed on a relocation, all right?
Understood.
Okay, because I think your mother lives in California, is that correct?
Mississippi.
Oh, Mississippi,
Yeah.
okay. All right, well, like I said, there's a pretty, we do have a motion, sample motion that you can utilize for that, all right?
Yes. Yes, Your Honor.
Okay, all right. Any other questions on my temporary order today?
No.
Okay, I want to thank you for your time. Take care. Good luck with your housing issue and court will be in recess.